Okay, I am recording a video for juvenile law. I'm in a latter part of the book, Pretrial, Detention, with or without bail, a right to bail under the 8th Amendment of the United States Constitution. And I'm going to read Schall versus Martin from 1984. Rehnquist delivered the opinion of the court. Section 320.53b of the New York Family Court Act authorizes pretrial detention of an accused juvenile delinquent based on a finding that there is a serious risk that the child, quote, may before the return date commit an act which, if committed by an adult, would constitute a crime. Appellees brought suit, end quote. Appellees brought suit on behalf of a class of juveniles detained pursuant to that provision. The district court struck down the rule as permitting detention without due process of law and ordered the immediate release of all class members. The Court of Appeals for the Second Circuit affirmed, holding the provision unconstitutional as to all juveniles because the statute is administered in such a way that the detention period serves as punishment imposed without proof of guilt established according to the requisite constitutional standard. We conclude that preventative detention under the Family Court Act serves a legitimate state objective and that the procedural protections afforded pretrial detainees satisfy the requirement of the Due Process Clause of the 14th Amendment of the United States. So that's, I'm guessing, what the U.S. Supreme Court may have said, which sounds to reverse the lower courts. Appellee Gregory Martin was arrested, so here's the facts, on December 13th of 1977 and charged with first-degree robbery, second-degree assault, and criminal possession of a weapon based on an incident in which he, with two others, allegedly hit a youth on the head with a loaded gun and stole his jacket and sneakers. Martin had possession of the gun when he was arrested. He was 14 years old at the time and therefore came within the jurisdiction of the New York's Family Court. The incident occurred around 11:30 at night, and Martin lied to the police about where and with whom he lived. He was consequently detained overnight. Martin brought a habeas corpus class action on behalf of those persons who are, or during the pendency of this action, will be preventatively detained, and sought a declaratory judgment that Section 320.53b violates the due process and equal protection clauses. Okay. So, next paragraph. No, next sentence. Clauses. At trial, appellees offered in evidence the case histories of 34 members of the class, including the 3 named petitioners. Both parties presented some general statistics on the relation between pretrial detention and ultimate disposition. In addition, there was testimony, next page, concerning juvenile proceedings from a number of witnesses, including a legal aid attorney specializing in juvenile cases, a probation supervisor, a child psychologist, and a family court judge. On the basis of this evidence, the trial court rejected the equal protection challenge as insubstantial, but agreed with appellees that pretrial detention under the Family Court Act violates due process. The court ordered that all class members in custody pursuant to the Family Court Act Section 320.53b shall be released forthwith. The Court of Appeals affirmed after reviewing the trial record, and the court opined that the vast majority of juveniles detained under this section either have a petition dismissed before an adjudication of delinquency or are released after adjudication. The court concluded that from the fact that 320 utilized, quote, principally not for preventative purposes, but to impose punishment for unadjudicated criminal acts, the earlier release of so many of those detained contradicts any asserted need for pretrial confinement to protect the community. The court therefore concluded that this section must be declared unconstitutional as to all juveniles. Individual litigants would be a practical impossibility because the periods of detention are so short that the litigation is mooted before the merits are determined. There is no doubt that the Due Process Clause is applicable in juvenile proceedings. We have held that certain basic constitutional protections enjoyed by adults accused of crimes also applies to juveniles, but the Constitution does not mandate elimination of all differences in juveniles. The state has a parens patriae interest in preserving and promoting the welfare of a child, which makes a juvenile proceeding fundamentally different from an adult criminal trial. We have tried, therefore, to strike a balance to respect the informality and flexibility that characterize juvenile proceedings, and yet to ensure that such proceedings comport with the fundamental fairness demanded by the Due Process Clause. The statutory provision at issue in this case